All right. Well, thanks everyone for joining us today. We're really excited to be hosting this fireside chat on legal issues and SMB acquisitions. There's a lot to cover, and I want to be efficient with everyone's time. So I think we'll just jump right in. Just one FYI, the webinar is being recorded, and it'll be shared after. So hopefully, no need to take copious notes, and hopefully allows everyone to be present and ask questions and so forth. Just before we get started, a little round of introductions. I'm Alex. I'm one of the co-founders of Rejigg. Rejigg is a platform that introduces business owners who are looking to sell their business to buyers of small businesses. So the Rejigg team sources leads via outbound calling to business owners that we think will be ideal for searchers and then puts them on our platform. Buyers can then reach out and schedule calls directly with these owners. So if you want to learn more about that, feel free to reach out to me after the session or check us out at rejigg.com. We are kicking off our first fireside chat here. We figured we might try to start doing things like this to try to provide some high quality conversations on search and SMB acquisitions. And I couldn't be more excited about our first guest and our first webinar here. We're thrilled to be joined by Laura DiFrancesco. Laura earned her JD MBA from Villanova University and has practiced corporate law at Richards, Leighton and Finger and Stradley Ronan before starting her own law practice. Sorry about that. Dean Street Law in 2019. She's now a staple of the ETA community. Many of you have probably seen her at conferences or met her before. She's worked on dozens of transactions in the sub $100 million space. And in addition to practicing law, she's prolific. She's developed her own course on business law and acquisitions that's available on her website. This is called Acquisition Insights and is a great resource for searchers to get some key resources and advice on business acquisitions. So the way we're going to run this here is I have 5 or 6 questions to kind of get things going. And so we'll go through those. And then if people have questions that come up during the webinar, please drop them in the Q&A. And we'll switch to those probably about 20 or 30 minutes into the webinar once we work through these. So be thinking of questions and drop those in. And I'm excited to be joined here by Laura.
Thank you, Alex. I'm so excited to be here with everybody, and I hope this is a valuable opportunity for everyone to elevate their deal-making skills. So please don't be shy in asking questions. I really want to best utilize this time, and I think one great way to do that is to really add value through that Q&A. So excited to hear the questions that everyone has, and so excited to speak with you, Alex. Thank you so much for having me.
Great, thank you. So before we dive into some of the tactics, I'm wondering if maybe you can set the stage a little bit and just tell us about your journey from big law into the world of ETA and SMB acquisitions, and then we'll kind of work our way into more tactical pieces. But can you kind of tell the story of how you got into this space?
Absolutely. I became a lawyer to be an entrepreneur, and that's really part of my story and journey. I've been attending negotiations since I was 3, a toddler, instead of preschool, and that really shaped my education and how I built my career. And so when I've worked in big law, I really was looking at it from an entrepreneurial perspective and having creative solution making at the forefront of my thought process in terms of learning what are everyone's hardest issues that they're going through and how can we creatively come up with solutions to navigate those in a more easy and satisfying, productive manner. So that was really at the forefront of my mind as I've had my career. I've been an M&A attorney for over a decade. And when I left big law, I was creating educational resources to support entrepreneurs when one of my Fortune 15 clients came to me and said, we need you to handle our deals, and prompted me to start Dean Street Law. I'm really excited to bring the skills that I have at a very high level of negotiating multi-billion-dollar transactions into the ETA space. I believe it's an underserved space where there's so much value that I can add by sharing what I know in this space. And I'm very passionate about that as an entrepreneur myself. And I'm very excited to continue this conversation. It's something that I really enjoy, having conversations in the ETA space, given that it is so community driven and entrepreneurial. So something I'm very glad to support and continue.
Awesome. Well, so the questions I have here, I'm wondering if we can just kind of start at a high level and work our way down to some more tactics. I guess just to get started, you've met a lot of searchers, you've been to a lot of these conferences. Can you tell us a little bit about what a searcher looks like who's really operating at the top of the game, at the top of their game when it comes to legal preparation for their search? what activities are they doing? What documents do they have ready? What activities aren't they doing during their search? Just can you tell us a little bit about what you think like a 10 out of 10 looks like in terms of a searcher who is prepared for the legal aspects of an SMB acquisition?
Law is the fabric of business, and it's especially the fabric of deal making. And so it's going to drive strategy and structure and terms. So someone who's at the top of their game as a searcher is really not only just spending time allocating to outbound searches and creating that funnel of opportunities for themselves, but they're also educating themselves on how the legal aspects of a deal will drive its success, because it's truly going to be one of the biggest determinants of not only your upside, but also your downside. And so I want to be able to share with people how they can maximize their upside, which we're going to be talking about in detail today, and also how can we minimize your downside. And so thinking about deal making as a lawyer, putting on that hat of issue spotting, of strategic positioning and creative solution making, those will elevate your deal making skills tremendously. And so it really depends on your background and what you already have as your information and skills going into this process, and being honest with yourself and evaluating, what do I know and what don't I know? What areas can I improve upon and what do I need help with? And that adding legal aspects and knowledge and skills to your repertoire can drastically increase the value of your transaction. It will immediately add to your bottom line, because if you're a good negotiator, you can drive value tremendously. If you know how to work through terms and structure, you know the implications of things, all of that's going to drive the value that you take out of this opportunity. So that's going to be your direct investment of your time, energy, and resources into elevating your knowledge and support in your legal aspects of your deal will directly translate to the profitability and economic success of your transaction as well.
Really tactically, I guess, what are some like documents that you would recommend searchers keep handy? You know, obviously, I think a lot of searchers like maybe carry around a stock NDA to use with sellers. Is there anything else like that? And you know, what are some of those documents that you think a searcher should have handy?
Mm-hmm. So through Acquisition Insights, I provided a course of over 80 modules of the legal aspects of buying a business, everything from pre-LOI, strategic structuring, whether it's going to be an asset purchase or a stock purchase. And in addition to those 81 modules taking you through the beginning all the way through post-closing of a deal, I also have our bundle of templates, and those are the documents that I really think are the key aspects of having a good arsenal of battle-tested templates. I'm very wary about folks who are just pulling a template off the internet and don't know the implications of the terms of those templates. They don't know what it means. They don't know what's missing. They don't know if it goes into court, how it will be interpreted. And so we provide our battle-tested templates in our Acquisition Insights course and templates bundle. And that includes your non-disclosure agreement. The non-disclosure agreements that you receive will generally be one-sided. They're going to be very pro-seller, because they're the ones generally drafting it. Whoever has the pen, it's a good thing to know in negotiations and deal making, whoever has the pen has the power as a general rule. And so when you're looking at that NDA, you want to make sure, is it mutual? Is it actually going to protect me and the confidential information that I'll be sharing as well? We also have a pre-LOI due diligence request list. It's important to do a certain fundamental level of legal due diligence before submitting an LOI, because that will drive structure. And I just had a conversation with one of my clients this morning about contracts in the target acquisition company, because that will drive whether we're able to do an asset purchase or a stock purchase. They have a lot of government contracts, and that's a important pre-LOI legal due diligence question. We also have your post-LOI due diligence request list, a material deal terms list, and that's going to drive your conversations about the material terms in your transaction, your purchase price, how that purchase price will be paid. Is it going to be in a seller note? Will there be an earnout? Will there be an escrow indemnification holdback? Will there be a deposit? And we go through all the different material deal terms for the various different transaction documents. And we also have our battle tested letters of intent, so that if you're looking to do it yourself, you not only have a template, but you also have a video that's going to go in depth, telling you exactly how each provision should be customized, what it means, what the implications are. So it's important to have that arsenal of battle tested templates if you are going to be doing those parts of the transaction yourself. Of course, at Dean Street Law, we do provide letter of intent negotiation services. We provide consulting for deal structure and deal terms. So we're able to assist that from the very beginning of a transaction all the way through your post-closing items that you want to take care of as a first matter of priority. So those are the things that I would be thinking about as a searcher.
Yeah, makes sense. Those are really helpful, having an NDA, having a diligence checklist, both pre and post LOI before getting into that process, I think makes sense for sure. I guess, one service I know you provide, because you provide it for some of the people on our platform, is an LOI review, where, and I know you work with both buyers and sellers in some cases, and I think you've done it for a few of our sellers as well. I'm just wondering, at a high level, if we can get into the head of, Laura, as you open an LOI for the first time, what are some of the key, where do your eyes go first? What, obviously there's kind of purchase price, but what are the things that you really start to look at if you only had 5 minutes to read an LOI? What are the things that your eyes are darting to, just to kind of make everyone on the call maybe a little bit better at looking quickly at an LOI and analyzing it?
I do have a very comprehensive LOI checklist and complimentary LOI checklist and masterclass. So if you want to dive deeper onto this topic and see if the LOIs that you're drafting have everything that I'd recommend in it, definitely check that out. From an overview, what I'm thinking about is deal structure, implication, and what's missing. The biggest things that I see missing in letters of intent are key economic terms that people want to wait later to negotiate. And that's okay if you wait later, as long as you have mechanisms within the letter of intent of how to negotiate it. So if you have the expectation that there will be a working capital target and you will have a working capital adjustment in the purchase price, but you don't have anything about what that working capital target is, or most importantly, a mechanism of how it will be determined, then you're really missing a key economic term within the LOI. And the economic terms are going to be the hardest terms to renegotiate or add in later or have significant changes in. So when you're thinking about a working capital target, for example, I always say, if we don't know what the working capital target is, let's say that it includes working capital, a normalized amount of working capital based on the trailing 12 months as of this date, generally as close to closing as you can get it. And so if you don't know, because I know that financial due diligence is going to be ongoing and you need to find out what that is, that's one thing. The other thing is, what are your assumptions? This is missing in many, many letters of intent. Are your assumptions that the transaction and the enterprise value is based on a cash-free, debt-free, tax liability-free basis? Is that your assumption for your how you've calculated the purchase price? If so, that needs to be in there. If you have certain assumptions about either work in progress or accounts receivable or accounts payable, you want to make sure all of those are considered. Now, they may be considered in your working capital adjustment, or they may not be. It just depends on structure. And then also, let's dive in a little bit more into the seller note. A lot of folks have been talking about seller notes. They've been talking about forgivable seller notes. One of the biggest mistakes I see people making is actually legally writing it out as a forgivable seller note. Legally, it should be a variable seller note. It is colloquially termed a forgivable seller note, but legally it's a variable seller note because you have to have the principal vary. And if you have it forgiven, it's taxable to the beneficiary, which would then be the borrower. You don't want that to be taxed. So from a legal perspective, that should be variable. And then diving deeper into the seller note, I often see important terms missing here. So is that seller note going to be subordinated to your senior debt? Typically it needs to be, especially if you're going to have any sort of loan, conventional, SBA, anything. And then also, are you going to have set off and clawback provisions whereby protecting you in the event that something happens post-closing? What's your real recourse under the deal? You don't want to have to sue the other party if there's an issue. And so if you have financial obligations to be performed, one of the ways that you can have a solution and recourse if there's something that goes south is to have set off and clawback provisions. The other option is an escrow indemnification holdback. Both of those are solutions to safeguard against post-closing surprises. Obviously, these are all going to be what the buyer and seller will agree upon, but I want to make sure that if there's key terms that are assumptions in the deal, that those are documented in the transaction in accordance with the letter of intent, because the letter of intent will be the entire foundation of your transaction. Diving a little bit deeper into the seller note, is there going to be a personal guarantee? Is there not? If there isn't going to be a personal guarantee, that should be in the letter of intent. If there is, or if there will be a corporate guarantee, what is the term of that guarantee? Because it's hard to ask for that after the letter of intent has been signed. And the assumption is if it's not in there and it's a material term, it's probably not been agreed upon by the parties. So those are a couple things in terms of the seller note. Obviously, you need specifics around interest rates, when it's payable, etc. But those are the key things that I see are missing. And then if you do have those set off and clawback provisions, do they have a certain time that they sunset, or are they durable for the entire duration of the seller note? So those are a couple key important aspects. And then in terms of diving deeper into it, think of what other economic terms might drastically impact the valuation of the business or the value of the transaction to the parties. Is there an assumption that rent is a certain amount for a lease if the seller is retaining the property? Is there an assumption that there will be transition services either included as a part of the purchase price or separately? And then detailing what those transition services are. What's the expectation that the seller will maintain a relationship with the buyer post-closing? Will they be on for 6 months? Will it sort of go down over time and step down their responsibilities? What does that transition look like? And if there's other key assumptions, such as consents that need to be acquired, financing that needs to be obtained, or employment agreements or other ancillary transaction documents that need to be signed, all of the assumptions, contingencies should be in there, as well as your material transaction terms.
Awesome. That was really helpful. I think maybe tell me if I'll do kind of a brief attempt to summarize that, and you tell me if I got this missed anything big. But essentially, the most important thing is like key economic terms like working capital targets. It's important to define the seller note appropriately in a way that isn't going to lead to any adverse outcomes, including like unwanted taxation, clawbacks, duration, and terms. And then all the transition services, including things like leases and rents, are really critical to not have to, kind of create the framework for in the exclusivity like diligence period. Would you say that's a fair summary?
That is a fair summary. And if you want a cherry on top of all of that, it's even better if you can also agree upon how the transaction will be taxed. If it's an asset purchase, will it be taxed as an asset purchase? If it's a stock purchase, are you electing for it to be taxed as an asset purchase? That all of these things, the more difficult conversations you can have early on in the transaction, the greater your likelihood of getting to closing, and the more that you can minimize the likelihood of broken deal costs. That's not in every deal, but it is the cherry on top I love to see.
Yeah, I love that. Okay, great. That was really helpful. I guess I want to do kind of the same thing for the for the purchase agreement. Similar question, what are the key things that your eyes go to the first time you open up a purchase agreement, and what are some of the key things you would be looking for if you were reviewing one?
The number one thing I think of when I'm thinking of the purchase agreement is, does it appropriately, effectively, with clarity, document the intent of the parties? So the purchase agreement should be completely based off of the letter of intent, unless there's been a change of terms between the parties. So when I'm pulling up a purchase agreement, I have right next to me the letter of intent. A lot of things that people miss are very simple in the purchase agreement, and this can also impact your letter of intent. Who are the owners of the business? Who has to sign off on this transaction? And do you have the appropriate people who are a party to the transaction documents? So if you have an asset purchase, the legal person transferring those assets will be the company. And then you have to make sure that it's properly authorized. If you have a stock purchase, you want that stock purchase to be entered into not only by the company, but the sellers are actually the stockholders. So the stockholders are going to be selling it, so they need to be a party, but then the company should be a party too, because there will be representations and warranties, not only on behalf of the company, but also on behalf of the stockholders. So that's something I see missing, fundamental structure components that sometimes people don't think about. And then going to fundamentals too, do spouses have ownership interest? Something a lot of people miss, and sometimes the confidential information memorandum says this, but I like to put in the LOI exactly who owns the equity interests in the business. And I want all of those equity holders to be signatories to letter of intent so that I'm confident that all of them are signed off on the transaction. A lot of times through due diligence, we find out that there are additional owners that weren't disclosed. It happens more often than you can think. And so not only will the letter of intent, but also all the due diligence findings directly influence the terms of the purchase agreement. And so we need that information to be able to properly structure it and make sure that it's legally effective. Imagine spending millions of dollars on a business that the purchase agreement and transaction documents don't hold up because the due diligence wasn't properly completed, the consents were not appropriately received, all the checks boxes weren't completed essentially. So I really look at fundamentals first. Those are going to drive a lot of the structure. And then I'm also thinking, and sometimes this is something that people glance over because they're not as familiar with deal structure, is do you have one company selling all of their stock or all of their assets? Or do you have a holding company and subsidiaries and all of those assets or stock need to be transferred? And if there's real estate, are those all going to be transferred under the same purchase agreement or separate purchase agreements? So when we're talking about formal documentation, I'm really zooming out, seeing the forest, getting all the information, making sure from a structure standpoint, we are solid. And then in terms of terms between the parties, what am I looking at the most? I really dial into working capital adjustments and making sure that not only does it appropriately document the intent of the parties, but also does it logistically make sense? Does everything logistically make sense? Are we having reports that are going to be delivered within a few days of closing? Can they actually be done? Are we having conversations with the financial team of how easy we can prepare those reports? If there's an inventory walkthrough, when does that need to happen? And so logistically thinking of how do we need to transfer the business? If it's an asset purchase, we have to transfer each class of assets separately. So our due diligence will inform what assets need to be transferred and how they need to be transferred. Those are going to be transferred through separate ancillary documents. A bill of sale will transfer personal property, and an assumption of contracts will transfer contracts, so on and so forth. There's many different ways to transfer different classes of assets, but we're thinking through logistically too. Bank accounts. If it's an asset purchase, are we closing down bank accounts? Does the financial institution have a way logistically to transfer ownership of those bank accounts, or do we need to shut them down and reopen them? And how will that impact customer payments? Because that's immediately going to impact your financial position on day one. Is there going to be any sort of interruption of your receipt of accounts receivable or making accounts payable, making payroll? And so that's going to influence how we need to structure closing, what our closing deliverables need to be, as well as our closing contingencies. And so I think people think that we care about the words, and we do for sure, but I also care about what position will you be in on day one post-closing? How easy of a transition will that be? Are we thinking through all the things that we need to in order for that to be a successful transition for you? And a lot of the time that's going to be driven by the working capital that's included post-closing, those accounts receivables, accounts payables, inventory, and the logistical aspects of the business and the transfer.
That's great. I'm glad that there are smart people like you thinking about things like this, because thinking about, your customers on day one not being able, their payments for the products not going through because you changed the bank account number, and that would be not a fun thing to deal with as a new business owner on day one. Just a quick plug for the Q&A. If people have questions, I can keep going, but also if people have questions, feel free to drop them in the Q&A or the chat. I guess, Laura, I'm wondering if you can maybe tell a war story or two here. One where maybe things went, the way you hoped they would. The buyer and seller got legal counsel at the appropriate time involved. The deal went off well. Everybody was happy with each other, and there were no lawsuits afterwards. And maybe another one where things didn't go so well, where for one reason or another, or legal counsel was involved too early or too late. And I'm just wondering if you can maybe share some interesting stories from maybe one from both of those camps where things went well and one where things did not.
Absolutely. For a situation where something went well, I would say that's the vast majority of transactions that we're working on. We're very proactive with how we work with our clients. We love to have weekly meetings to make sure that everyone's on the same page, that we're talking and communicating about key deal terms, and there's just an opportunity to touch base on a regular basis. We also initially provide folks with a closing checklist and a closing timeline. We like to prime them with our general suggestions on the timeline of that exclusivity period and how they're using that. Generally, you want the first 30% to be dedicated to due diligence, but making sure that after that 30% is complete, that you are drafting the transaction documents, because it does take about that 60% of the transaction or more to be able to draft, negotiate, and finalize all of those transaction documents. It typically is going to take at least 10 to 20 transaction documents to close a deal. And so we have a very consistent approach to deal making. Obviously, we always are doing what's in the best interest for our clients and always communicating with them on the positions that they want to take, advising them on what the issues and the options are, and letting them take the lead on decisions. But our overall general basis that we take is a friendly approach to deal making. And that will get you so far, because when you have what benefits you, benefits me, benefits us all mentality, it's so much easier to get to closing, find mutually beneficial solutions. And so when we draft our transaction documents, they're fair, but they represent our clients well. So we have had a number of transactions where we have had maybe less than a handful of comments to an entire purchase agreement and set of transaction documents. We've had them signed without any comments to the majority of the transaction documents. And I think that's a testament to how fair our transaction documents are. On our last transaction, the opposing counsel wrote me a nice email saying, "Thank you so much for these transaction documents. I can't even explain to you the state of transaction documents that we've seen from other prospective buyers." And it goes so far in maintaining that momentum to continue moving a deal forward. It's a very precious time period that you have in that exclusivity period to use it well and effectively and successfully. And part of that is to continue that momentum and that forward progress. If things are fair to begin with, neither party feels like they need to climb a mountain to get this deal done. And that climbing a mountain to get the deal done can really hamper your success and your momentum in a transaction. So we want to set our clients up for success, represent them very well. They're very well represented in the transaction documents, but it's not going to be oppressive to the point that it's going to be something that we can't get a deal done with. And so Those have been the easiest, breeziest transactions to work on. I will say, I think that is derived especially so from the positioning of the parties, how they approach their negotiations and their communications along the way. If you have well-intended parties who are represented by attorneys and deal teams that know what they're doing and can represent them well and are all vested in the interest of successfully transacting business, and that doesn't always mean that a deal should be closed, but if the intent is for it to close, to successfully get there, and communication along the way, explaining when the other side can expect to receive transaction documents, letting them know that it's under review, letting them know timelines for due diligence, and when we expect to start drafting transaction documents, when we expect to start them, and really managing that process well from a project management standpoint and communication standpoint. The transactions that I have seen fall apart, while they are few and far between, I would say it's primarily driven by one, poor documentation. And so number one thing that will make a transaction go south is going to be whether financially there's the wherewithal or not. Does it stand up financially to the analysis? Do the economics make sense? That's going to be the number one reason whether a deal goes forward or not. The number two reason whether I think a deal goes forward or not is the personalities, how they're treating one another. Is someone getting too personal about something? Are they getting their ego involved? If someone throws out, one of the biggest mistakes you can make in deal making is saying something is non-negotiable. While we hear it, the term tossed around, it's not an effective negotiation tactic because it draws a line in the sand that can be very hard to overcome, because you either need to say you're wrong or they need to say you're right, or you have to come up with something so different that it doesn't trigger any of those emotions. So the better thing to do if something is very important to you is to explain why it's important to you, explain the motivations behind it, ask questions, be a listener, figure out what motivates them, what's driving their decision making. Not only what are the internal factors, but what is influencing those internal factors and who is a part of that conversation. Understanding the stakeholders that may be a part of those decisions is very important, and understanding what the elements at play there are can be really fundamental in being able to find solutions that will work not only for you, but also for them. And so instead of saying something's non-negotiable, I always recommend my clients say, I would love to learn more about why this is important to you. Here's why it's important to me. Here's how it's affecting me and what it will influence. And being transparent and really getting beyond the surface of the terms to the motivations.
I like that. That's probably good advice for a lot of parts of life, to not throw around the phrase non-negotiable. All right, we have some great questions here in the Q&A. So, Laura, maybe the first one here from Viraj here. Thanks for your question. From a financial diligence perspective, what aspects of a PPA should one look for other than reps and warranties to make sure the client is adequately covered? It's always tough to go through 150 pages of a typical PPA. And I'll just say for those, I believe PPA stands for purchase price allocation. And Laura, I'll turn it over to you.
Mm-hmm. So from financial due diligence, I would also be looking at those key financial elements that I mentioned, your working capital adjustments, your target working capital, what are accounts receivable and accounts payable, what is the accounts receivable aging, are those really collectible or are they not? If something's been outstanding for over 60 days, is that person really going to pay it? And how much is the accounts receivable and accounts payable? As well as inventory. Sometimes work in progress is a very big part of the business, and it really depends. Do they have obligations? And what are their payment mechanisms in the business? Are they being paid ahead for work to be done, and so they may have a negative working capital? Or are they being paid afterwards and have to then put all of their resources on the line to be able to provide those goods or services and then need to collect it. So really, what are the payment mechanisms and the flow of funds in the business? I like to say wherever the money flows, there should generally be contracts or understanding between the parties. And so while you're asking about financial due diligence, a related topic that I am always thinking about are if we have $100,000 or $500,000 customer, do they have a contract? What does it say? Can that evaporate instantly, or is there an obligation for notice? Is there some obligation to continue that business? And then also, when you're thinking about financial due diligence, also think about what are the tax allocation, that's purchase price allocation. How will the transaction be taxed? And then I like to think of if there are elements such as a seller note, what are the exact terms of that? Are there set off and clawback provisions? What's the overall economic picture of that? And so that may be more than just the purchase price. It may also include rent, may include seller note. Overall, what are the economics of the transaction, and what's influencing those economics?
Makes sense. Next question here from Josh. What is your reaction if a seller is insisting on a breakup fee at the LOI phase, other than perhaps screaming? I would think that this pushes the LOI closer to a purchase agreement, and it also ramps up buyer protections in that LOI, including escrow, etc.
So there's a couple of different aspects to think of with a breakup fee. Is what they are asking for reasonable, and why are they asking it? And so it seems like if there's a seller who's asking for a breakup fee, they're concerned that they are going to start engaging counsel and start to expend a considerable amount of fees and not really know at what point we are going to closing or not. And so one way to negotiate that is to say, let's have an initial exclusivity period of, let's say, 75 days. And if we haven't finished the transaction in 75 days, then we can put up a non-refundable deposit after that point. Or if they won't agree to 75 days, what period would they agree to where you can feel confident that you can complete the financial due diligence? And can we make it mutual? What if they terminate? What if they walk away? So how can we address this that addresses their concerns, and how can we make it more fair? And so there's a lot of different ways that you can do that, whether it's moving it to a different time, or moving it until after you have a purchase agreement. You can do a deal where you have a purchase, you have a letter of intent, and then you sign a purchase agreement, and then you work on everything else. And so maybe it would make sense to have a breakup fee after a purchase agreement has been signed, or after a significant amount of an exclusivity period, or it could only happen in certain cases as well. What would be the trigger for that breakup fee? Would it only be triggered if you act in bad faith, or if you walk away from the deal after a certain period of time? And also, what happens if they act in bad faith, and what are your options as well?
Great. Yep, makes sense. I've heard a lot more discussion on some of these panels about breakup fees on both sides, about sellers demanding it, but also in some cases owners talking about searchers trying to demand these. And I think these are tough to negotiate, but I think some of the structures you mentioned make a lot of sense here.
And if you don't mind, yeah, I'd love to add one more thing. So a deal where I think it makes sense and where we've incorporated it, it doesn't always make sense, but sometimes it does. So the buyer wanted the seller to reorganize the business in order for them to sell it, but they want to have a purchase agreement signed at closing. So they don't want to sign a purchase agreement before, but they want the seller to go through the expense of having an entire reorganization. And so that expense should really be the buyer's expense if they walk away. So that would be an example of somewhere where it would make sense.
Yeah, makes sense. Next question here from Sam Smith. Good to hear from you, Sam. How do you see the role of technology evolving in the legal aspects of SMB acquisitions, and how will it affect transparency and efficiency in the process? I think if I could add some, maybe broaden this as well, I think there's maybe at least two directions to take this. One is everyone wants to talk about AI and how it might change everything, including SMB acquisition. So I'm curious your take there. And then maybe if I could also just broaden to say, obviously the SMB space has changed a lot in the last 10 years. There's been a lot more interest and so forth. So just curious if you can comment on kind of the overall transition of the space in the last 10 and maybe next 10 years as all the different trends have kind of collided into the space.
AI and technology will drastically impact the M&A space, from how we negotiate, how we communicate, to the roles that people have. It is something that we use on a legal basis. I don't recommend using it on a consumer basis unless you know what you're doing, but we do have, legal providers, we have research providers, and so we have databases of law and codes and cases, and they're very expensive, but we do have AI being implemented into those tools so that we can better access research, so that we can better draft contract provisions. But that AI is all based on a library of well-vetted legal resources. So it's not going to be creating hallucinations or anything like that. So it's something we use in our business. It's very expensive, but it's a worthwhile investment for us. I think that you'll see more and more resources, but there's so much that you can do in AI to better your position as well. You could have a conversation with ChatGPT and say, I want to learn more about mergers and acquisitions, act as the best M&A attorney and act as the best teacher in the world to teach me about, or to explain what a target working capital peg is, what a working capital adjustment is. And so you can use it in beneficial ways. The tough thing is that it can't be used in isolation. You have to have knowledge of when it is giving you good information and when it's misdirecting you. And it's also really important to know that it's not comprehensive. And so while we do use these tools, we never use these tools and then just implement them. We always look through everything and understand the ramifications of it. I think there's going to be a limited way that it will impact law. You may be able to take information. So if you have a template, for instance, you can more quickly plug in information into that template. But ultimately, does that template even serve you, or does it not serve you? And I have never sent out a document without looking over every single provision to make sure that it made sense, and to think about that document with respect to the exact transaction we're working on and what's missing and what other implications we need to think about. And those are all driven by deal term structure and what comes up in due diligence findings. So I think it'll have a great impact to efficiencies, and I think it can make you better in your deal making skills, and why not use it? But do use it with a lot of oversight, and know what you know and know what you don't know, and be very cognizant about not letting it lead you astray. Because if you ask for what are the material deal terms, those are not going to be the comprehensive material deal terms that you need to be thinking about, because it only has so much capacity. It's a tool and not to be used more than its capacity to be used. And then in terms of AI overall in M&A, I think you're going to see a lot more opportunity for different aspects of M&A to involve, whether that is the search process. We've seen that through the evolution of platforms and processes and how people are doing outreach. But you also have to think of what's working for me and what's not, and what do I want to stand behind. Just because something is available doesn't mean that I want to engage with it, doesn't mean that I want to use it. And so you have to be very discerning now, because there's an AI app for everything under the sun today, but does it do well? I have had clients send me AI generated arguments that made absolutely no sense for our transaction whatsoever. They were like, I was thinking about this issue and this is what I put in ChatGPT and this is what it came up with. And I was like, well, none of that makes sense, because That's not relevant at all to what we're talking about. So you have to be very discerning, but I think it can really help us evolve in many different ways, from technology and platforms and tools that we have, resources that are available. And I think it will also elevate overall each participant in the deal making process, whether that is the buyer or the seller or advisors or anyone else.
Awesome. Well, I think that's a great place to end. Webinar in 2024 wouldn't be complete without an AI discussion. I'm sorry that the questions we didn't get here. Feel free to maybe follow up with us afterwards if you have them. And thanks again, everyone, for the time. We'll be sending a wrap up, and feel free to reach out if you have any questions. Laura, some great resources on our website, and we'd love to see you on our platform as well. Thanks again for your time, everyone.
Thanks, everyone.